Good morning, everyone. Welcome to this webinar, Common Pitfalls in Cross-Border Personal Injury Claims. My name is Vaughan Jacob. I'm a barrister at 39 Essex. I'm 2009 call, and I specialise in personal injury and clinical negligence claims, both from the claimant and defendant perspective. I've got a special interest in cross-border personal injury claims, and I'm joined today by...
Hello, I'm Caroline Allen. I'm also a barrister at 39 Essex Chambers. I'm 2005 call, and like Vaughan, I have a practice that specialises predominantly in personal injury and clinical negligence litigation, and I too have a particular interest in cross-border claims.
Just a few housekeeping points before we start. Luckily, there's no fire exits to talk about today, but I can tell you that the webinar is being recorded. So if you log on to 39's website, you'll be able to access the recording of the talk and also the slides that we're going to go through today. You can also access a number of other webinars on a whole range of topics. We did do a webinar, the Personal Injury Cross-Border team, in December, looking at what might happen post-Brexit and what legislation would be in place and how that would affect cross-border claims. So this is an update following that December webinar. We're now more certain of the position and more able to tell you the common pitfalls that you'll encounter in practice. There's also, you'll see on your screens, I hope, a Q&A feature. So if you have a question that comes to mind throughout the webinar, please do enter it. We may not be able to deal with all questions today, but we'll certainly email you afterwards with our advice. So please do use that feature. So without further ado, what are we going to talk about today? As aforementioned, we're going to talk about the position before and after Brexit. We're going to look at issues related to the choice of law. So if you have a client who is resident in the UK, but was injured in a road traffic accident in Spain, you need to examine what law will apply. Will it be English law or will it be Spanish law? We're going to look at jurisdiction, so where the claim is seized and which courts will have power over the procedure and the hearing of the claim. We're going to look at enforcement and whether, if you obtain a judgment post-Brexit in this forum, in the courts of England and Wales, can you enforce that judgment in a foreign jurisdiction? Caroline's going to look at pitfalls in service and CPR 6. And then we're going to talk generally about some potential difficulties and how the changes will work in practice. The first and most important issue at this point of time in March, after we left the EU on the 31st of December, is what's changed since the end of the transition period. The terms of the UK's exit were agreed in two pieces of legislation: the withdrawal agreement, which was the EU Withdrawal Agreement Act 2020 and the EU Withdrawal Act 2018. Now, we were saved great difficulty in the transition period because the transition period implemented, by virtue of that legislation, a period where EU law continued to apply as if the UK remained a member state. So Brussels I recast, dealing with jurisdiction and enforcement, was still in place for the last few years. So from a legal perspective, between the period when the UK withdrew on the 31st of January 2020 and the expiry of the transition period on the 31st of December 2020, things have largely remained the same. Now that date has been and gone, we need to look at what rules now will govern the applicable law and which rules will govern jurisdiction and enforcement. And the first issue, choice of law, thankfully, is the easiest issue. So pre-Brexit, there are two pieces of legislation which looked at what law will apply in a particular forum. Rome I dealt with contractual obligations. Rome II deals with non-contractual obligations or torts. So in the personal injury context, when we're dealing with road traffic accidents or we're dealing with occupiers' liability accidents, it's Rome II that will be the starting point. Both Rome I and Rome II continue to apply until the end of the transition period. And as I said, thankfully, The position now is they've both been incorporated into UK domestic law, and that's by virtue of the legislation on the slide, the law applicable to contractual obligations and non-contractual obligations, EU Exit Regulations 2019. Given that it remains in force, it's worth just having a recap of the main points of Rome 2 and when you're considering a choice of law argument. So let's say, for example, you're a UK national and you have an accident in Spain, whose law is going to apply? The general rule under Article 4.1 is it's the law of the country in which the damage occurs. And that's irrespective of the country in which the event giving rise to the damage occurred, or irrespective of the country or countries in which the indirect consequences of that event occur. So you'll notice there's what's distinguished is the occurrence of damage from the event giving rise to damage and from indirect consequences. What does that mean in practice? Well, consequential loss or indirect consequences arise in a fatal accident claim. So where a deceased dies abroad, but the repercussions, the loss, are felt by a family back home, the damage occurs in the foreign territory. And that will usually be where that law applies. So in our scenario, if somebody dies in an accident in Spain, that's where the damage occurs. And usually that would be the loss. And that's where the law would apply. It wouldn't be the case that the dependents back in the UK who are suffering loss in this jurisdiction would establish a choice of law for the purposes of Article 4.1. And a case to illustrate this example is the case of Lazar and Alliance. Very briefly, Mr. Lazar resided in Romania, and his daughter, sadly, died as a result of an accident in Italy. And Mr. Lazar sued the Italian insurance company Allianz. The European Parliament found that his fatal accident claim was what they termed ricochet damage. It was indirect loss occurring to someone other than the person who had suffered the tort, in that case, the daughter. So looking at Article 4.1 of Rome 2, the country in which the damage occurred was Italy, not Romania, and therefore Italian law applied. That's the general rule under Rome 2, but there are a number of exceptions. And the first exception is that where the claimant and defendant both have their habitual residence in the same country, then that country's law applies. That's Article 4.2. This is a question of fact, which will be determined on the circumstances of each particular case. And one case in which Article 4.2 was discussed and considered was the case of Winrow and Hemphill, which you'll see at the bottom of the slide. In Winrow, the claimant was a UK national, and she was injured as a rear seat passenger in a road traffic accident in Germany in 2009 in a car driven by the defendant. Her car collided head-on with the defendant's car, and the defendant admitted negligence, so liability wasn't an issue. The claimant had moved to Germany with her husband after he was posted there by the British Army, and they'd been living in Germany for over 8 years at the time of the accident. They lived on a British Army base. They had 3 children who attended a British Army school, and the claimant was in fact employed at that school. So she clearly had ties with the German jurisdiction. However, the claimant argued she always intended to move back to England a few years after the accident, and she brought her claim in England, arguing that English law should apply. And the court had to consider both Article 4.1, where the damage occurred in Germany, and 4.2, whether the claimant's habitual residence was in England. As for the habitual residence of the claimant, the court considered she'd been in Germany for a long period, she was in full-time employment, her children were schooled there, but her intention to return one day to the UK was held to be irrelevant, notwithstanding that the defendant also had ties to England. At the time of the accident, she was habitually resident in Germany, and therefore German law applied. Another exception to the general rule under Rome 2 is found under Article 4.3, and this is a much higher threshold. where the tort is manifestly more closely connected with another country, that country's law applies. And manifestly, in this scenario, is likely to mean exceptionally. And in Winrow and Hemphill, the case we've just been discussing, the claimant also argued, if she failed in respect of Article 4.2 and proving habitual residence, that Article 4.3 applied. Because of her ties to England, it was appropriate that English law should apply. So the court considered not only habitual residence and the factors that we've already discussed, but also a few additional factors under Article 4.3. The fact that both the claimant and the first defendant were resident in England at the time of the trial, as opposed to the time of the accident. The fact that the second defendant, the insurer, had always been habitually resident in England. The fact that the claimant continued to suffer pain and require medical treatment on her return to England, and the fact that the proceedings had been issued in England. So the court took those factors on one hand and considered on the other hand that the accident had happened in Germany, the injury had been sustained in Germany. At the time of the accident, both the claimant and defendant were habitually resident in Germany, and that the claimant had lived there for an extended period. Now, those latter factors, in the court's view, outweighed the claimant's ties to England, and again, Article 4.1 wasn't displaced, and the applicable law was German law. So you can see, even in a case where there are significant ties to another jurisdiction, the threshold under Article 4.3 is high, although sometimes such an argument is successful. And the case of Marshall MIB there, I won't go through in detail for time purposes. That concerned a claim brought by a UK widow whose husband died in France, and Article 4.3 was successfully employed in that particular case. Once the applicable law is selected, let's say in Winrow the applicable law was German law, what issues does it cover? And this is dealt with by Article 15 of Rome II. Article 15 defines matters which the courts must treat as governed by applicable law, and they include liability, contributory negligence, the assessment of damages, vicarious liability, and crucially, limitation. Applicable law, German law in our scenario, doesn't govern evidence or procedure. Those are matters for the law of the forum, i.e. where the claim was issued. So if the claim was issued in England, the applicable law was German law, matters of evidence and procedure would be governed by the CPR, by English law. The case at the bottom there, Pandia and Inter Salonica, is a useful case to look at, confirming that limitation is not a procedural matter. In that case, the claimant was a UK national on holiday with her family. She went to Kos in Greece, and sadly, she suffered a motorcycle accident and suffered a traumatic brain injury. Her family brought a claim in the UK courts against a Greek registered insurance company pursuant to Rome II. There was a problem with service, however. The claim was received by the court on the 25th of July 2017, 4 days before the 5-year anniversary of the accident. Although it was received by the court within that 5-year anniversary, it was issued months later and not served for another 5 months. Now, the applicable law for limitation was Greek law, and so a 5-year limitation period applied and not a 3-year limitation. But the defendant argued it was statute barred under Greek law, which required issue and service to take place within 5 years from the date of the accident. Both parties adduced expert evidence from Greek lawyers who agreed that service was necessary under Greek law to stop limitation. The claimant, meanwhile, argued that service was a point of pure procedure and that the CPR applied. Although Greek law applied, the relevant date prescribed by CPR 7.2 was the date the court received the claim form, and therefore the claim was properly brought for limitation purposes in the claimant's argument. And in considering both the claimant's and defendant's positions, Mr. Justice Tipples found that service of a claim form as a matter of Greek law is an essential step which is necessary to interrupt the limitation period. Service of the claim cannot be severed, carved out, or downgraded to a matter of mere procedure, which falls to be dealt with under English civil procedure rules. that, apart from anything else, would give rise to a different limitation period in England and Wales than in Greece. The clear intention of the Rome II regulation is to promote predictability of outcomes, and in that context, it seems to me that such an outcome is not what the regulation intended to happen in these circumstances. So the claim was dismissed. Though the case concerns specific requirements under Greek law, the judgment is relevant for us all dealing with foreign limitation periods, and it did provide some welcome clarity. What's important to note is the use of expert evidence in that case on Greek procedure and Greek limitations. So when you're dealing with a cross-border personal injury case, you'll often have to instruct an expert in that particular jurisdiction to obtain evidence on service and limitation. And that's something that Caroline's going to talk about in due course, and she's going to look at the future of Rome I and Rome II in domestic law now.
Hello. As Vaughan said, Rome I and Rome II have been incorporated as retained EU law, no doubt to the considerable relief of very many. As to whether this is likely to change in the future, substantially, no, I wouldn't have thought so. There is such a long established regime incorporating Rome I and Rome II, not only within the UK jurisdiction, but of course Europe-wide, that I can't really see that there would be any motivation for seeking to disrupt that. That said, the retention is set out under Section 6 of the EU Withdrawal Act 2018. And actually the status of the legislation post-Brexit is interesting. Looking at Section 6, post-Brexit decisions, whether incorporating Rome I and Rome II or not, are not to be deemed binding on the courts, which is actually a fairly substantial deviation. Under subsection 2, the courts may have regard to anything done on or after the exit day by the CJEU, another EU entity, or the EU, so far as it's relevant to any matter before the court or tribunal. But of course, the decisions of the CJEU are no longer binding, and it may be that there is significant deviation in the future, or of course, it may be that this is a more incremental process. Those decisions will, of course, remain persuasive. Quite how persuasive, of course, is likely to be a matter of fact and degree, but certainly in the short term, I think it unlikely that there will be any substantial deviation from those judgments, particularly if they are dealing with fairly weighty matters of substantive law. And subsection 3, any question as to the validity, meaning or effect of any retained EU law is to be decided, so far as it remains unmodified after exit day, as far as relevant, in accordance with the retained case law and the retained general principles of EU law, which again is a pragmatic basis on which to proceed. And of course, it would cause very considerable confusion were we to proceed in any different manner. However, critically, of course, the Supreme Court is not bound by any retained EU case law. And this, I think, is a matter of considerable importance going forward. Its impact isn't likely to be felt by some time, given the amount of time that it takes for cases to reach the Supreme Court. But it may be that several years down the line, what we're looking at is, in fact, some divergence. Under subsection 5, in deciding whether to depart from any retained EU case law, the Supreme Court must apply the same test it would apply in deciding whether to depart from EU law. And consequently, it's evident that it's going to require very careful consideration, and that certainly in respect of any significant change, it's unlikely that this will be brought to bear in the near future, but it's something that it's worth looking out for. Also, I think of some importance is that in the interpretive subsection 7, the reference to retained case law provides that this is the law as modified by or under this Act or by other domestic law from time to time. And consequently, not only is it likely that there will be some incremental differences emerging as a result of case law, but there is specific scope within this Act for legislative divergence to emerge. Again, it may well be over a fairly lengthy period of time, but it's likely that there is going to be a measure of legislative divergence, particularly given that the case law, of course, will be developing as shaped by the CJEU, in parallel with any divergence as set out by the UK courts. Differences of interpretation, I think, are also likely to be something that are more, something that's more sort of visible in the shorter term. The case of Brownlee, which Vaughan is going to discuss in greater detail, is perhaps an interesting example of this. It's a case concerning an accident that took place in Egypt. The claimant's husband was killed in an accident when they were on holiday. She was injured, and she wishes to bring her claim for damage to be assessed in accordance with English law. The Court of Appeal, as stands, has said that yes, she is able to do this. And this has been taken to the Supreme Court, which heard the matter in January, and judgment is yet to be handed down. But certainly the decision of the Court of Appeal, and as I say, Vaughan will discuss this in greater detail, does seem to have widened the scope of damage suffered out with the jurisdiction, or rather it seems to have incorporated within its decision determination as to whether or not consequential loss, which on the face of it is suffered in the UK, can properly be deemed to be damage that has been suffered within the jurisdiction. Could I have the next slide, please? I'm in Vaughan's hands here. Thank you very much. Jurisdiction and enforcement prior to the 31st of December 2020, or 11 p.m. thereof, was governed by Brussels recast. The Lugano Convention too, though this was of significantly lesser significance whilst we were still members of the EU, Legano essentially runs along the same lines as the Brussels regulation, of which Brussels recast was an upgrade. Brussels recast was intended to iron out some of the problems that had emerged in respect of the regulation. But broadly speaking, the structure and the legislation was really very similar. Again, it was of relatively limited significance, generally governing accidents that occurred where the defendant was domiciled in Iceland, Norway, or Switzerland. Common law rules captured most other cases, and there were, of course, the freestanding travel conventions, Montreal concerning accidents taking place in respect of airline travel, Athens in respect of carriage of passengers by sea, and Bern in respect of carriage of passengers by train. Now, it's not to say that there were no pitfalls, and 1 year limitation period under the Montreal Convention springs to mind, but the law was at least relatively settled when these particular pieces of legislation were in force. Of course, it's worth saying that the travel conventions, Montreal, Athens, and Bern, remain in force because they are freestanding. Turning then to the position now. Sorry, Vaughan, thank you. Thank you very much. Brussels 1 recast and Lugano ceased to apply as of 11 o'clock on the 31st of December 2020. This, I think, in respect of Lugano, was not, in fact, what we had hoped or what the government had hoped. I think what had been envisaged was that there would be a relatively seamless transition to Lugano, and that consequently this would be the law that would be applicable as of that date. But this, of course, hasn't happened. The transitional provisions sort of cushion the blow to an extent. If English courts are seized of cases which have not been concluded to that date, the relevant instruments continue to have effect in relation to questions of jurisdiction, recognition, or enforcement, as if those instruments had not been revoked. The court is seized when the document issuing proceedings is lodged, and this is a critical point because it's lodged rather than issued. And this, of course, is consistent with English case law, which has determined that the lodging is the critical issue because, of course, the actual issue of the court documentation is then a matter that's out with the parties' control. Essentially, but the sting in the tail is that this is only the case as long as the document is then duly served. I'll be dealing with service later on, and of course service is an area which is rife with pitfalls. But the critical matter really is that if a document is not served appropriately, what then is the position? That is something that we'll be looking at later, but certainly on an initial reading of the regulations, it would appear that essentially you may then have to sort of go right back to the start, and that the court will not be automatically seized for the matter. The English courts will not be automatically seized for the matter. This is essentially the same concept as within Brussels 1, a recast. As to jurisdiction and enforcement post-transition, as I said, UK was previously a party to Lugano via its EU membership and not as an individual contracting party. I believe it had been envisaged that we would simply make our application to become a party to Lugano in our own right, pursuant to Article 72(1), and that application was made on the 8th of April 2020. Accession requires the unanimous consent of all existing parties, who should endeavour to give consent within a year. So we're butting up relatively closely to that deadline if consent is to be given. At present, there have been indications of approval from Switzerland and Norway and Iceland, but nothing from the EU itself. And according to reports within the Financial Times, the Commission in fact advised that there were good reasons why it would not necessarily be in the EU's best interests to allow the UK to accede. If the UK is then invited to become a party to the Convention, it deposits an instrument of accession, and subject to any further objections, the UK will become a party 3 months thereafter. Consequently, the Lugano Convention, if agreement is to be reached within the 1 year deadline and then the 3 further months are to apply and there's to be no further period of delay, we are not going to be a party to the Convention until July at the earliest, and it looks as though it may take rather longer than that. As to what Legano would mean in practice, there are critical differences. Lugano is deemed to be the sort of oven-ready solution because essentially the text of Lugano follows Brussels 1 very closely. It's essentially a sort of a generation behind. But there are critical differences. There's a significant measure of similarity, of course, and it has the benefit of being something that has formed part of a fairly familiar legislative landscape. But Brussels recast was intended to iron out difficulties that have been experienced by contracting parties operating under Brussels 1. The most obvious difference is that the CJEU currently plays a role in ensuring uniform and consistent interpretation of the rules, where, of course, the parties can refer questions in respect of the operation of the Brussels recast to the CJEU, and this would no longer be the case for the United Kingdom. Under Lugano, contracting parties must pay due account to CJEU case law in respect of Brussels regulation and the Brussels recast, but arguably that's a relatively weak obligation, certainly from the EU's perspective, where what is wanted is consistency and uniformity. The potential for there to be divergence and for there to be a contracting party which is not in fact obliged to follow the approach that has been set down by the CJEU is likely to be problematic. There are also particular difficulties with Lugano which were identified under Brussels 1, particularly the attractively named Italian torpedo, where it's a jurisdictional device which is operated, and whereas under Brussels recast, if there is an exclusive jurisdiction clause within an agreement, then essentially if a party issues proceedings in a different jurisdiction, those proceedings must be stayed if the other party then issues proceedings in the contractually provided jurisdiction, the applicable jurisdiction. That was not the case under Brussels 1 and is not the case under Legano. And the point of the Italian torpedo is that a party can effectively frustrate and delay litigation by choosing to issue in a jurisdiction which is notorious for proceeding very slowly. And that jurisdiction is then, proceedings must then continue within that jurisdiction, and that jurisdiction is seized of the issue as to which jurisdiction, which country's law ought then to apply and which courts are in fact correctly seized of the matter. And that can be a lengthy and complicated process and is intended to stymie proceedings and has been seen to operate fairly successfully in so doing. And one of the purposes of Brussels recast was to remove the force of the torpedo and to ensure that exclusive jurisdiction clauses operated more effectively. There was a case recently, a case of Master Melt and Siegfried Evianet, which was an English-Swiss case, which effectively set down very clearly that there cannot be an optimistic reading of the Lugano Convention, such as what one may say, well, effectively, what one can read into it is that the exclusive jurisdiction provisions of Brussels recast ought to apply. Lugano Convention doesn't provide for that, and there is no scope for interpreting it in a matter which does. That consequently is a difficulty. There are simplified enforcement procedures under Legano, but they're not as simplified as they are under Brussels recast. I know that enforcement is something that Vaughan again is going to talk about. So if it is to be Legano, it's a good solution, but it's not a perfect one. And frankly, it's not really as good as Brussels recast, but we are where we are, and where we are presently is that we don't, of course, even have Lugano. As to the present position, if there are no other provisions in place, then other than cases which are governed by the Transport Conventions, largely thrown back on the common law rules in Practice Direction B. And this is something that Vaughan is going to talk more about.
Thanks, Caroline. So, as Caroline said, recast regulation is no more. It ceased immediately upon expiry of the transition period. So we're left with no comprehensive reciprocal regime in place between the UK and the EU for determining which member state court should take jurisdiction, or for the recognition or enforcement of judgments. So whereas choice of law, which I discussed earlier, is straightforward because we've re-implemented Rome 1 and Rome 2, we're now having to fall back on the common law. And at present, jurisdiction and enforcement are dealt with under CPR 6. Other EU member states, such as France, Spain, Germany, have their own national laws, their own CPR 6, if you like, which respect parties' freedom to choose which courts should hear their disputes. So we anticipate lots of toing and froing and lots of arguments about which is the correct jurisdiction. The certainty provided by Brussels 1 is no longer. What does CPR 6 tell us? Well, Practice Direction 6b, paragraph 3.1 contains all of the general rules, that being that the domicile of the defendant is the starting point. So general principle is the defendant is entitled to be sued in their own jurisdiction. It also contains rules on joining additional defendants and third parties who are necessary and proper parties. In respect of tort, there is a jurisdictional gateway found Practice Direction 6b, paragraph 3.19. So in order to establish jurisdiction against a foreign defendant, you need to pass through this jurisdictional gateway now. And that is that a claim is made in tort where damage was sustained or will be sustained within the jurisdiction, or damage which has been or will be sustained results from an act committed or likely to be committed within the jurisdiction. What does damage within the jurisdiction mean? This was an issue which was dealt with in the case of FS Cairo and Brownlee, which Caroline alluded to previously. Very briefly, the facts are as follows. In January 2010, Lady Brownlee's husband was sadly killed in a car accident in Egypt during an excursion booked through the Four Seasons Hotel operated by FS Cairo, the defendant. Lady Brownlee was also injured. The driver was convicted of involuntary manslaughter, and way back in December 2012, the claim commenced in tort and contract against Four Seasons Holding Incorporated. And this litigation has been ongoing ever since. The claimant brought the claim in this jurisdiction, Lady Brownlee, firstly for her own personal injury damages, but also in her capacity as her late husband's executrix. And she brought her claim for bereavement and loss under the Fatal Accidents Act. The latest round of proceedings, having gone all the way up to the Supreme Court and back again, and now currently awaiting judgment in the Supreme Court, concerns permission to serve the claim out of the jurisdiction and the jurisdictional gateway under CPR 6, because in order to serve and in order to bring the claim within this jurisdiction, Lady Brownlee has to show that it falls within a jurisdictional gateway under CPR Practice Direction 6B. And what she argued, and what the Court of Appeal agreed with, is that although the road traffic accident occurred in Egypt, the loss, the consequential loss, i.e. the fatal accidents claim, and the losses flowing from the injury occurred here. And therefore, looking at the wording of Practice Direction 6B, if we go back to the previous slide, that damage will be sustained within the jurisdiction. The defendant, on the other hand, opposed, reading the gateway in this way, citing the argument that the damage was sustained in Egypt and not over here. The Court of Appeal decided that consequential loss was sufficient to establish jurisdiction, and as you can see, an appeal is to be heard, or has been heard in January 2021, and we're awaiting judgment. So on this particular point, and on the jurisdictional gateway under CPR 6, I recommend looking for that decision. Even if you establish a jurisdictional gateway under CPR 6, there is now another hurdle to pass, and that's the hurdle of forum non-convenience. Now, this is one of the most significant differences between the rules of Brussels 1 and Lugano and the English and Wales common law jurisdiction. Whereas beforehand, there was mandatory jurisdiction, and generally, under Brussels and Lugano, once jurisdiction was established, it couldn't be declined by the court, subject to very limited exceptions. Now, even if jurisdiction is established, the court has a discretion to decline jurisdiction in favour of the courts of another country if it rules that that country is the more appropriate forum. So now what we'll find is defendants raising a number of arguments and a number of factors which they say means that the litigation shouldn't take place here. So they're going to be looking at factors such as the number of connected parties, the number of witnesses, the ease in which those witnesses can travel, whether any site visits should take place, the impact of transferring the case, the possibility of conflicting judgments, problems in enforcing judgments, and also the costs of the proceedings. And simply this argument about whether there is a more appropriate jurisdiction, I think, will lead to more time and expense being expended on cross-border personal injury claims than was the case previously, because with Brussels 1, we had a mandatory jurisdiction, and arguments about transferal were certainly more difficult. Now, that argument, I think, we'll see much more frequently. Another significant difference under the new regime is the end of Odinbright. You may be very well aware of the Odinbright case. The ratio was that an injured person with a claim against an insurer could bring the claim in their own national court, provided there was a direct right of action, or if the law relating to the insurance contract provided one. That is no longer, and instead, a claimant will have to establish a jurisdictional gateway under Practice Direction 6B, as we've just discussed. Now, insurers might be raising their hands in glee. Historically, insurers didn't like the Odinbright principle because it meant that lots more claims were brought in England where there are higher damages and legal costs than if they'd been litigated in France or Spain or Germany. But it may be a Pyrrhic victory, because as I said, what we're likely to see is more litigation surrounding the forum non-convenience argument and more costs associated with that, as opposed to having a certainty that the right jurisdiction has been established. The last point on the slide is another significant difference, and that relates to UK residents injured by untraced or uninsured drivers abroad. The usual position would be, pre-Brexit, to contact the MIB. And the MIB had a scheme in place, a compensation scheme with its own rules of procedure where claims would be submitted, and the MIB would assist such a claim. Unfortunately now, post-Brexit, the MIB will no longer consider claims relating to accidents caused abroad by uninsured or hit and run drivers. They will be able to provide details of their opposite number in another jurisdiction, but it's likely that you'd need certainly to go to them in the first instance and possibly expert evidence on foreign law to decide the strength of your claim. That deals with jurisdiction. I'm going to talk very briefly about enforcement. And because Brussels I recast is no longer, again, in terms of enforcing a judgment, we need to fall back on the common law rules. And that can be found under the lesser spotted CPR 74. If you want now to enforce a judgment which was obtained in another jurisdiction, you need to make an application. You need to show that it's for a definite sum, that it's final, that it hasn't been issued in respect of taxes, penalties, or multiple damages awards. And also, generally, courts in England and Wales will not give judgment permitting enforcement where it's found the original court lacked jurisdiction according to the relevant English and Welsh conflict of law rules, or if the judgment was obtained by fraud, is contrary to public policy or the requirements of natural justice. So we may also find arguments that if steps are taken to enforce a judgment which was obtained abroad, that there were problems with those underlying proceedings, that they were obtained by fraud, that there wasn't a fair trial, or that it's contrary to the jurisdictional laws of England and Wales. So whereas beforehand we had certainty about enforcement of judgments, now again, we're very much in the Wild West of the common law, and I can see more arguments being raised on these simple issues. Service is also a bit more difficult now, and Caroline's going to talk to you about that.
Thank you. First takeaway point is that as there was previously not on the face of it any need for permission to be obtained from the courts to serve claims issued under Brussels recast, that remains the case for claims that have been issued prior to 11 p.m. on the 31st of December 2020, regardless of whether or not service has been affected, although service must then be affected appropriately. Otherwise, the likelihood is that you'll have to go back to stage one. So the critical issue is when the claim was lodged. It is worth mentioning that the saving provisions that made those transitional provisions possible, there is a loophole within them. The transitional provision refers only to the previous version of CPR 6.332, which concerns Brussels recast, and not to 6.331, which is claims brought pursuant to the Lugano Convention. And consequently, if a claim was issued in respect of a defendant domiciled in Iceland, Norway, or Switzerland, was issued prior to the 31st of December but wasn't served, there may then now be a need to return to the court in order to obtain permission to serve overseas. I don't believe this was anticipated by anybody. It's a loophole that's highlighted within the present supplement to the White Book and is likely to be in the new version thereof. I haven't heard that the loophole has been shut yet, though hopefully that is something that will be addressed because it is anomalous, albeit that it's likely only to affect a relatively limited number of claims. In respect of claims that were lodged, issued after the 31st of December, firstly, the critical thing to do is to look at whether or not there's a contractual agreement in place concerning service. The likelihood is that there won't be in the vast majority of personal injury claims, but nevertheless, that's something that ought to be looked at. It's also worth considering whether there is an exclusive jurisdiction agreement in accordance with the Hague Convention 2005, to which most EU countries are signatories. Again, relatively unlikely, frankly, to be in place in the personal injury context, but it's something that's worth looking at because the convention does then stipulate the appropriate requirements for service. There's a very helpful website governing that, which sets out any limitations which countries have placed upon the appropriate forms of service which they're prepared to acknowledge, and that is well worth checking. There's a wealth of information there. Otherwise, assuming that there isn't a contractual agreement in place and that the Hague Convention doesn't apply, permission will be required under CPR 6.36. The hurdles to be overcome are threefold. Firstly, is there a serious issue to be tried on the merits of the claim? Really, this is pretty much what it says. You have to establish that there is a serious issue requiring determination, which ordinarily would be the case in litigation, but it's simply intended to be a hurdle that dismisses claims that are frivolous or potentially vexatious. Secondly, is there a good arguable case that the claim falls within one or more of the heads of jurisdiction under paragraph 3.1 under the practice direction 6b? Again, it's something that will simply turn on its facts, but of course now there is a need to have particularly close consideration and to give a particularly close reading to the practice direction in order to ensure that the claim does fall within the heads of jurisdiction. Thirdly, in all the circumstances, is England clearly or distinctly the appropriate forum for the trial of the dispute? And in respect of this, it's the common law of foreign nonconvenience which will apply, as Vaughan has discussed. Next slide, please. As to alternative service, there are, of course, provisions for alternative service under the CPR 6.15 and 6.27. It's anticipated, of course, that this would very much run contrary to what would ordinarily be expected. Generally, it would be 6.36 that would apply. There would be a need to obtain foreign law evidence, as Vaughan has previously discussed, in respect of jurisdiction regarding the CPR 640 restriction in order to ensure that this was not prohibited by local law. There is also potentially the scope for a CPR 6.16 application, dispensing the service retrospectively. So if it's felt that service has gone disastrously wrong, that it hasn't been effective and that there is consequently a problem, this is something that there is a means of redress, but the courts use this generally very sparingly, and usually if there's only been a relatively minor technical problem, then certainly parties would need to demonstrate that they had done everything reasonably possible in order to effect service. Law Society guidance. The Law Society has published guidance on enforcement of foreign judgments after the end of the transition period. There's a link there, which provides a wealth of information. There is also a revised notice that has been published by the EU as to how conflict of law and jurisdiction issues will be determined post-Brexit. Doesn't make any mention of Lugano. There is also the UK guidance. This is a good guidance note. It's up to date, it's relatively comprehensive. It also envisages the UK not being a party to Legano, as of course it isn't at present. Now, what we wanted to look at is problems in practice. Firstly, I've got two concerning service. If a claim form is lodged but not issued before the 1st of January, will Brussels recast apply? The short answer is yes, it will. I've governed that one previously. It's the time at which the documents were lodged, which is critical according to the regulations previously cited, Regulation 95. If the claim form is issued by 31st of December but not served, will Brussels recast still apply? Yes, it will. But do note that it is service that's of critical importance. And if service isn't affected, then albeit that there hasn't been any case law on this at present, but I think the overwhelming likelihood is that a party will have either to make an application to extend the period of time for service and would have to give a very careful explanation as to why it is that the UK courts ought to extend that, the English courts ought to extend that, particularly in light of the fact that the transitional period has come to an end. Alternatively, if the courts are not minded to do that, there may then be a need to bring fresh proceedings. And of course, the permission of the court would then expressly would have to be sought in order for service overseas to be effected. And if a party isn't able to provide, again, a very careful explanation as to why it is that service wasn't effective in the first place, my suspicion is that the courts are likely to take a fairly dim view of this. And there may be concerns as to whether or not this is an abusive process. As to whether there is a way out, it's worth looking at whether there are alternative methods of service which may be affected. It's worth also, of course, giving very careful consideration to limitation periods, because if service hasn't been affected within a particular period, certainly as Vaughan has said in the case of Pandya, where date of service affects effective limitation period, which of course is a matter of applicable law, then a party may well be left with nowhere to go if limitation has expired due to the fact that service hasn't been effective. So it can be a bit of a minefield, service, but I think there is a very considerable need to do what needs to be done as early as possible, not least because the foreign process section at the High Court, it operates very slowly. There are considerable backlogs. There is, of course, the impact of COVID as well. I think if a party is able to demonstrate that documentation has been lodged, that has been filed there in good time, the courts may well be relatively sympathetic to any applications that may be needed in order to extend time for service. But if a party has been pushing up against the deadlines all the time, my suspicion is, again, that the courts may be rather less sympathetic. Proceedings have been incorrectly served or issued prior to 2021. How is this now rectified? Really, these are points that I've gone through previously. Of course, everything is going to turn on facts. Everything is a matter of fact and degree. My key takeaway point would be that if you have looked at a matter and have identified the fact that something has gone wrong, the critical thing, I think, is to put in an application as quickly as possible and set about trying to rectify matters as quickly as possible. If service has been incorrect, but there have been genuine efforts to effect service, and perhaps there have been minor technicalities, this is something to which the courts are generally relatively sympathetic. If, however, and I have dealt with cases where there have been a litany of errors, the court may well take the view that, unfortunately, proceedings are not salvageable and there is really no means of redress. Limitation, as we've said, is and can be extremely important. It's worth noting that parties we tend automatically to think of the 3-year limitation period that applies to personal injury claims within this jurisdiction. That can, of course, differ fairly widely across other jurisdictions. Vaughan referred to a Greek case in which the applicable period of time was 5 years. Under Dutch law, for example, a claim brought against an insurer, which many personal injury actions are, the appropriate limitation period is 4 years. So there may be a get out to that extent, and that you can then serve proceedings against a party and not butt up against limitation as is pressing an issue. But it is, of course, important to obtain expert evidence on limitation periods within each country in order to make sure that errors don't occur. Local law can, again, provide a potential escape route. For example, there was a claim relatively recently that was brought in Poland where there was simply a different right of action against insurance companies, and consequently the proceedings that had been brought in the UK courts couldn't proceed any further due to a litany of procedural errors, but there was a get out in that a different set of proceedings could proceed in Poland on a slightly different basis. So it is, if things have gone catastrophically badly wrong to the point where the English courts have determined that you can no longer proceed with a particular piece of litigation, it is always worth seeking expert advice as to whether or not there is any sort of alternative route that can be pursued in a different jurisdiction. There may not be, but it's worth looking at.
Thanks, Caroline. I'm just going to deal very quickly in the last 5 minutes with some jurisdictional problems. The first, probably most important point in respect of jurisdiction is procedural. If you want to challenge jurisdiction when you receive a claim form, you must tick the box in the acknowledgement of service saying that you intend to dispute jurisdiction. Following that, you need to file an application within 14 days of filing the acknowledgement of service, giving the reasons you contest jurisdiction. The relevant rules are CPR 11, subsection 4 and 5, and there's a very tight time frame in place. And if you fail to either tick that box or file the application in time, the court will not be very sympathetic. There is a possibility to circumnavigate the application. If you tick the incorrect box, if you fail to make your application within 14 days, you can make an application under Part 23, either withdrawing the acknowledgement of service or setting it aside. But this is tricky because effectively it'll be an application for relief from sanction. You'll have to explain why you tick the incorrect box, which can often be very embarrassing. And the court will ask, why didn't you do it right the first time? So although there is that escape route under Practice Direction 10, paragraphs 5.4 and 5.5, it's best to get it right first time. I'm just going to deal with a scenario tying up everything that we've been discussing today with a classic example of a cross-border case. You have an English domiciled claimant who is injured in a road traffic accident in Spain. What hurdles do you now face post-Brexit? Well, importantly, as I discussed earlier, you can no longer rely on the Odinbright principle. So you can't serve service claims representatives of the insurers, and there's no direct right of action against those insurers in the law of England and Wales. Instead, you need to establish jurisdiction under the Jurisdictional Gateway in Practice Direction 6B, and you need to obtain permission to serve on the tortfeasor outside of the jurisdiction. Even if you manage to go through that gateway, you may then face a forum nonconvenience argument. And the questions to be considered will be, where are the witnesses? Was there a police investigation? Can the witnesses travel easily? Are there any connected claims? Is there the possibility of conflicting judgments? All of those factors will be discussed in deciding where is the proper forum. You'll also need to consider what is the correct choice of law. Although Rome II is still in place, and so we're more familiar with the current regime because it mirrors the past regime. Foreign law, if the accident happened in Spain, is likely to apply, and it's likely to be Spanish law unless you can show either that the claimant and defendant share a habitual residence, or the case is manifestly more closely connected with the courts or with the jurisdiction of England or Wales. You're going to have a problem if it's a hit and run accident, because the MIB will no longer provide you with assistance. And if you obtain a judgment in this jurisdiction, you're going to have trouble enforcing it in Spain. And likewise, if you obtain a judgment in Spain, you're going to have trouble enforcing it here, because the Brussels I recognition of judgments in EU jurisdictions has gone. Just dealing with this last point on enforcement, luckily for proceedings commenced before the end of the transition period, let's say the claim was instituted, it was lodged, it was validly issued and served before the 31st of December 2020, then any judgment which is now subsequently obtained will still fall under the old regime. So Article 67.2 of the withdrawal agreement provides for the continued recognition and enforcement of judgments in claims instituted before the end of the transition period. If you're not in that fortunate position, you've issued a claim today and judgment arises in a few years' time, the current position is that foreign judgments can only be enforced by an action at common law or under CPR 74. So as we discussed earlier, at common law, a foreign judgment, it can't be enforced here except with the institution of fresh legal proceedings, and the cause of action of those legal proceedings is the foreign judgment. And the court will need to consider the circumstances in which that judgment was obtained, whether it's final, whether it conflicts with the jurisdiction of England, Wales, before granting permission. So it's a much more costly and it takes a lot longer to enforce a judgment than it did in the previous regime. We are coming up to 11:30. In fact, it's 11:31 now. Caroline, I don't know whether you can see if any questions have been asked, because I'm sharing my screen. I don't want to.
You see, I don't have any on the screen before me. We wanted to say that if anybody does have any questions, we had one that came in just before we started the talk, which we will respond to. I think now that we've reached 11:30, unfortunately, we're probably going to have to respond to that by way of email. But if anybody does have any questions that have arisen as a result of the talk, and I hope we haven't depressed you too much in sort of stressing just how much more convoluted matters are going to be in future, please don't hesitate to email either of us, and we'd be very happy to reply as soon as we can. If there is to be a sort of silver lining to the talk that we've given, I think it's firstly that these are problems which are going to have to be ironed out, particularly in respect of claims that would previously have been dealt with by the MIB, because the position as it stands is wholly unsatisfactory, and it's something that will need to be addressed. And of course, the second point is that inevitably in the meantime, there will be more work for lawyers. So it may not be great news for either clients, individual clients, or potentially insurance companies, but anything that generates more work for lawyers is of course something to be celebrated and applauded. Not that, I have to say, I feel that this has been dealt with particularly well to date by the government, but we are where we are. And it's an interesting period, and there will inevitably be change. It may simply be that we proceed to Lugano, and it may be that other provisions are put in place which broadly mirror what was in place previously, because it was generally acknowledged to be a reasonably good system. But we shall see.
Thanks, Caroline, and thank you to everyone for joining us this morning. We've dealt with a lot of content today. There's a lot of slides. So if you want to look at those slides again, they'll be available on the website, and indeed the recording of this webinar will be available there. As Caroline said, if you have a question that comes up in practice, please do email us. We'd be more than happy to help. And thanks, Caroline, and thanks everyone for joining.
Thank you.